I now invite Professor Brian McGarry from Leiden University. He's Assistant Professor of Public International Law at Leiden and visiting professor at Sciences Pro Law School and Vermont Law School to be the first discussant. I'm glad we're now in situ. So I give the floor to Professor McGarry.
Well, thank you very much. Excuse me, Judge ATTARD. That was, from my perspective, a grand understatement. It is, speaking personally, an enormous pleasure and a privilege to be in situ with you. I can only echo the thanks that we've already heard to the ministry, as well as to the Korean Society of International Law. I want to personally thank Professor Yoon and Ms. Claire Cho for the incredible organization and bringing us all here. Thank you, Judge ATTARD, for moderating this. I'd like to thank Professor NERI for really being the hero of this panel, jumping in only a few days ago, and I'm sure I can speak for my friend and colleague, Professor Hyun Kim, when I remark about how wonderful it was to learn from you in this presentation. Professor Tanaka, it is I am deeply regretful that I did not get to see you in situ because, as fate would have it, I first met Professor Tanaka when I was pursuing my primary law degree in the United States, and I decided, somewhat on a whim, to study abroad for a semester at the University of Copenhagen. I was taken with Kierkegaard at the time, and that was pretty much it. And I decided, rather randomly, to take a course on the law of the sea. I had studied maritime law, but I didn't know the difference, and I had no footing in public international law, and little did I know that that course would lead me essentially here today. So thank you very much, Professor Tanaka. It is indeed humbling to be asked to say a few words in response to your masterful presentation. In the time allotted to me, I'm going to try to tie my remarks on these two presentations to our conference theme and to the theme of the effectiveness of UNCLOS, and in so doing to tie it to as well our panel theme, the peaceful use of the seas. Looking ahead to the remaining panels that we have in this wonderful conference, which I am equally excited simply to be a spectator, I can't help but notice the emphasis on dispute settlement. Rightly so, of course, this is organized in conjunction with the Tribunal, but I think as well because the peaceful use of the seas is inextricable from an effective model of dispute settlement. And so I'm very excited to see the panels that come later this week. I'd like to try to unpack, if I can, Professor Tanaka's reference to the tension between, on the one hand, the necessity of state consent in that model of dispute settlement, and on the other hand, the mandate of essentially every international court and tribunal to resolve the disputes submitted before it, which, of course, when you speak of ICLS, when you speak of the ICJ, very often has the specter of threats to international peace and security in the background, should they fail at that task. So by way of some background, leading up to the case discussion that we heard from Professor Tanaka, we had mere hints of this controversy concerning Article 298(1)(b to come in the Arctic Sunrise case, which reminded us why states might prefer to have their activities characterized as military rather than law enforcement. The fact that they invoked the military activities exception without having to tie it to EEZ fisheries or marine scientific research, which in turn recalls the framing game, if I could call it that, played in UNCLOS cases since at least the Chagos Marine Protected Area arbitration, and the question of incidental issues, or as Professor Tanaka recalled from Judge Gao's opinion, the mixed dispute character of the case that we have just heard. States might indeed prefer to have to gamble on this framing game as little as possible. But more specifically to the questions raised in Professor Tanaka's discussion of the Ukraine-Russia case, we have the South China Sea case as an ideal precedent. It reminded us of the blurring lines of Article 298(1)b when, for example, paramilitary forces or joint military and law enforcement operations are deployed, such as activities carried out by the China Maritime Surveillance Branch of the Chinese government. The South China Sea Tribunal found that it did not have jurisdiction over the Philippines' submission relating to a particular feature in the South China Sea's Second Thomas Shoal. Its 2016 award found that while the Chinese vessels in a standoff with the Philippines armed forces, quote, were not military vessels, China's military vessels have been reported to have been in the vicinity. In the tribunal's view, this represents a quintessentially military situation involving the military forces of one side and a combination of military and paramilitary forces on the other, arrayed in opposition to one another, end quote. Perhaps even clearer is the tribunal's 2015 award on jurisdictional questions, which focused on the engagement with a military target, regardless of the characterization of the state's own deployed vessel, referring to, quote, a dispute concerning China's activities in and around Second Thomas Shoal and China's interaction with the Philippine military forces stationed on the shoal, end quote. A case we may indeed hear more about in the panel on compliance with decisions. To return to Professor Tanaka's magisterial analysis and his taxonomical analysis, which is something that I look for in his scholarship generally. The 2019 Provisional Measures Order of the Tribunal for the Law of the Sea. Most of the judges who wrote separately, some of which are in this room, indicated that they considered the deliberations of the plenary tribunal to have yielded reasoning which was too succinct or perhaps too unclear on this particular point, a sentiment perhaps borne out by the arbitral tribunal in that case, subsequently issuing what you might call an about-face on the question of Article 298(1)b. I'll return to that with a little more nuance in a moment. ITLOS found that the distinction between military and law enforcement activities, quote, must be based primarily on an objective evaluation of the nature of the activities in question, taking into account the relevant circumstances in the case. And of course, I'm not going to repeat, nor could I attempt to emulate Professor Tanaka's dissection of that pithy statement. The tribunal looked at three such circumstances, generally: the nature of the underlying dispute, facts indicating the dispute concerned, quote, a differing interpretation of the regime of passage through the Kerch Strait, and the fact that force was used by the Russian Federation, quote, in the process of arrest. On this cumulative basis, the tribunal concluded that arrest and detention of vessels in that case was a law enforcement matter. I think it's notable that it reached this finding even though the Russian Federation was using armed force against another state's warship, returning again to the South China Sea perspective on the target, as the tribunal itself acknowledged by reaffirming its dictum from the ARA Libertad case, Argentina-Ghana, quote, that a warship is an expression of the sovereignty of the state whose flag it flies. Law enforcement, by definition, cannot extend into the sovereignty and territory of another state, a basic premise of state jurisdiction under international law, which we, as fate would have it, nevertheless see challenged today in the form of alleged Chinese police stations in foreign countries. So perhaps there is room for even greater objectivity in a decision claiming the mantle of an objective test. And I recall in this respect the keynote speech of Judge Pike and the first element that he noted as he laid out his vision of an effective legal order. We need clarity in the source of law itself, but where do we find it? perhaps not from the usual sources of clarity when it comes to this question. For example, the International Court of Justice, in its 2007 judgment in the genocide case, endorsed a non-formalist test that equates paramilitary activities with military activities when the state utilizes paramilitary organizations as, quote, in fact, the instruments of its actions. I don't think anyone in this room would find that to be particularly enlightening when trying to apply that to the facts of a live dispute. Nor do we necessarily find the clarity we look for in the UN Charter itself, where blurred lines arise as well in the use of force. Actions, of course, need not be of a military, quote-unquote, character in order to breach the prohibition on the threat or use of force in Article 2, Paragraph 4 of the Charter, as Professor Tanaka seemed to suggest when discussing the Guyana-Suriname case. Perhaps we might try to be less clever, or simply ask what makes the duck quack. For example, if the deployment in question happens to be an organ of the state into which its citizens may be conscripted, in most countries today that would make it military, not law enforcement. Yes, such an approach requires the tribunal or any international court or tribunal to assess the state's domestic legal structure at perhaps a granular level, though not as applicable law, but rather as a mere fact to be taken into account in the words of the Permanent Court of International Justice in the famous Khorzau factory case. And certainly international courts and tribunals are more than capable of assessing these domestic legal structures as fact, even a fact of a normative character, such as concerns nationality laws in cases of diplomatic protection. And this brings us to Professor Tanaka's masterful reading of Ukrainian Naval Vessels and Servicemen, Award of 2022, administered by the Permanent Court of Arbitration, where the arbitral tribunal has found months ago that the events of 25 November 2018 until the departure of Ukrainian vessels are excluded military activities, while events after the arrest of Ukrainian vessels are not military activities, the precise point of which it deemed suitable for determination alongside the merits, and we await with bated breath. So we have some apparent inconsistency, though, as I promised earlier, Professor Tanaka was of course right to inject some nuance into this. We must bear in mind the critical difference between a finding of a prima facie nature and a finding of a dispositive nature, and that has been with us since the very beginning of unclose dispute settlement in the Southern Bluefin Tuna case. But let us put this in perspective by reference to more provocative notions. Is the consistency of dispute settlement important to the effectiveness of the Law of the Sea Convention and the maintenance of peace and security through predictable law, for that matter? Or might that luck of the draw, that tabula rasa, be part of the raison d'etre for choosing arbitration in the first place, rather than a standing court? And indeed, baked into the very fabric of the Third Conference's grand compromise reflected in Article 287. Does this apparent inconsistency diminish the potential role of the Tribunal for the Law of the Sea and throw cold seawater on the relative popularity of agreeing to change forum from default arbitration and all of its expenses to a special chamber of ITLOS? In other words, respondent states by today must surely be on notice that their Article 298(1)(b) declarations might be more robustly preserved and interpreted by an arbitral tribunal than by the 21 foremost experts in the field. And so perhaps we might instead try to be more clever, more innovative, returning to the wonderful opening remarks we heard from both President Hoffman and Judge Pike. For example, by looking ahead to one of our upcoming panels through a well-framed request for an advisory opinion from the Tribunal for the Law of the Sea on the scope of Article 298(1)b, either from the meeting of parties or from a small international organization established for this very purpose, an innovation we see in the pipeline concerning the Commission of Small Island Developing States. Professor Tanaka underlined the need for interpretation of Article 298(1)b. And so I raise this prospect with, of course, a heavy grain of salt, having not thought about it for more than a couple hours, but I think that this is an opportunity for us to consider out-of-the-box ideas. Indeed, could there be any more relevant provision of the Convention for such a request regarding the effectiveness of the Convention than one of those few carve-outs in Article 298, and more specifically, the exception concerning the state's own day-to-day enforcement activities and the need for predictable guidance? That panel on advisory proceedings is yet to come, as is tomorrow's on boundary delimitation. Yet here too we may draw links to the preservation of peace and security in the practice of the Convention. We see in boundary delimitation under Articles 74 and 83 of the Convention the need to maintain the peaceful use of the seas, even in the absence of clarity as to which coastal state enjoys sovereignty in the relevant area. And I speak, of course, of the provision found verbatim in each of those articles concerning the requirement to enter into provisional arrangements of a practical nature and, during this period, not jeopardize or hamper the reaching of that final agreement. And this has become perhaps de rigueur to invoke in delimitation cases, such as, for example, Ghana-Côte d'Ivoire, or even in the absence of any purported threat to international peace and security, as seen in Mauritius's notice of arbitration, instituting proceedings against the Maldives before being transferred to a pending matter before a special chamber of ITLOS. And running through the limited exceptions of Article 298 in this manner, we return to Professor NERI's fascinating presentation on the role of the Security Council, which of course bubbles to the surface of UNCLOS in Article 298(1)c. And in so doing, we may recall the International Court of Justice's mutatis mutandis application of the customary rules of treaty interpretation to the resolutions of the Security Council, and perhaps recall as well in this light our deep dive into the ambiguity of Article 298(1)b and how that should be interpreted. This reminds us indeed of the concerns over fragmentation which the a la carte approach in UNCLOS engendered soon after its entry into force, and which we heard referenced both by President Hoffman and Judge Pike earlier today, with Judge Pike referring in this light specifically to ITLOS's unique, quote, institutional responsibility. The forums of Article 287, in other words, were not created equal. In this respect, if the ICJ were seized under Part 15 for the first time, it would dismiss for a pending Security Council action by applying Article 298(1)c. But if the ICJ is seized outside of this lex specialis, it returns to some gray area left unresolved, perhaps in the Lockerbie cases, concerning its precise relationship to the Security Council as a co-equal organ or as a kind of Supreme Court of the United Nations. And so, whereas we are wont, I think all of us in this room are wont to emphasize the Convention's ambiguities, here, its detail, in fact, adds clarity to international dispute settlement beyond what could be expected in its absence. And I recall as well in this regard Professor NERI's tantalizing suggestion that UN Security Council derogates from core principles of the Charter in this subject area. Perhaps this relativism, this benchmarking against the absence, against 40 years ago, is the appropriate way to judge effectiveness, comparing UNCLOS today to the absence of the Convention 40 years ago, reminding me of the vaguely skeptical Scandinavian pragmatism of Dag Hammarskjöld, And I'll paraphrase his famous dictum that the purpose of this great organization, the United Nations, is not to lift mankind to the heavens, but rather to keep it from descending into hell. So what of the next 40 years? The next generation, as we have the banner above our heads, and the next generation of treaties at that. Meet the new boss. Is she the same as the old boss? Well, when we turn to the BBNJ negotiations, which we all hope will resume, we see that in the most fleshed out form of the draft text released this year, indeed, we have the mutatis mutandis importation of Article 298 to dispute settlement under the BBNJ Treaty. There's a second, more skeletal option that makes no such reference, creating a standalone mechanism with a default of conciliation, a bilateral process, and therefore calling into question perhaps its effectiveness, and includes its own simplified version of Article 287-esque forum selection. So under that more skeletal option 2, the ICJ returns to the gray area in its relationship to the UN Security Council without renvoi to Article 298(1)(c) of the Convention. Article 298(1)(a) concerning boundaries and land sovereignty is reflected in both options, expressly in the former and essentially in the latter. Though this carve-out is perhaps ill-fitting to what is by definition beyond national jurisdiction. So we should bear in mind, perhaps, what role Article 298(1)(b) and (c) might have in this respect, bearing in mind as well that the Republic of Korea has a declaration in force which invokes all three exceptions. And while I'm not going to say anything that would traipse onto the incidental proceedings panel, I have to note that the Republic of Korea is the only state party to the convention. Well, the mic is off. Thank you. The only state party to the convention to have expressly in its declaration a reference to the right to intervene in proceedings, which shows me a commitment to multilateralism, apropos for the law of the sea, apropos for 21st century dispute settlement, and perhaps essential to the effectiveness of this legal order. So in conclusion, we've heard the discussion concerning the importance of cooperation through institutions. We've heard the discussion alluded to as well by Professor NERI regarding the requirement, the need for good faith bilateral relations. And the most senior member of ITLOS, Judge Jesus, wisely recalled as much in his opinion in the MV Louisa case. I look ahead to climate change. I look ahead to peace and security questions arising from maritime refugees. And I think that the peaceful use of the seas, while it has been a concern since the days of Grotius, today cannot be divorced from such existential challenges to states, to peoples, and to the planet. But I am confident because I look around the room and I see those of you who have been at the forefront of the development of this field since before I was born, since this was a young convention, and who are continuing to be at the vanguard of its development and to teach and to encourage the next generation. Thank you very much for your attention.
Thank you so much, Professor McGarry, for this insightful presentation. Extremely interesting points that were made, and particularly the concluding remarks, I feel, are very important to bear in mind. I now move to the next discussant, Professor Kim, from the home country, who is Associate Professor at the Department of Political Science and International Studies at the Yonsei University in Korea. Thank you.
Yeah, thank you, Chairperson. First of all, I would like to express my sincere gratitude to MOFA Korea, ITLOS, and Korea Society of International Law for inviting me to this conference. And I am very honored to discuss in the first session of ICLS under the chair of Judge ATTARD. Then I'm also very pleased to meet Professor TANAKA, although it is virtual because I have read Professor TANAKA's publications since I was a graduate student. Then it is also a great pleasure to be with Dr. NERI and my dear colleague, Professor McGarry, who gave me valuable comments for my recent publication. I'm very happy to be here to celebrate the 40th anniversary of the adoption of the UN Convention on the Law of the Sea. The convention was adopted in the early 1980s, so when I was also born. So we might say that we are in the same generation. As I grew up and got older, the convention has evolved and has been adjusted over the time. However, there are still some points and issues that have remained unclear and unresolved under the convention. The issues of military activities and the meaning of peaceful use of the seas are two such issues. We are all here to discuss peaceful use of the seas. It was interesting to listen to two presentations about this issue. I'm very grateful to Professor Tanaka and Dr. NERI for sharing very insightful ideas with us. UNCLOS has a few provisions explicitly referring to peace, as Dr. NERI addressed already. For example, Article 88 concerns the reservation of the high seas for peaceful purposes, while Article 141 provides that the area shall be open to use exclusively for peaceful purposes by all states. Unlike these two provisions, Article 301 is the provision applicable to all maritime zones. It is interesting to note that the content of Article 301 follows Article 2, Paragraph 4 of the UN Charter. As shown in negotiation history in the Third United Nations Conference on the Law of the Sea, states had a different point of views as to peaceful use and peaceful purposes in terms of the maritime issues. In this sense, it must have been a reasonable compromise to rely on the wordings of Article 2, Paragraph 4 of the UN Charter, which were already generally accepted. On the basis of provisions of UNCLOS concerning peaceful use of the oceans, we can conclude that not all military activities are prohibited. Military activities may be conducted unless they are incompatible with the UN Charter. Nevertheless, we witness that some states express their opposition to other states' military activities in their maritime zones. For example, Bangladesh and Brazil declared that, I quote, "The provisions of the Convention, UNCLOS, do not authorize other states to carry out in the exclusive economic zone and on the continental shelf military exercise or maneuvers, in particular those involving the use of weapons or explosives, without the consent of the coastal state." End of quotation. These declarations made under Article 310 of UNCLOS indicate that those who are opposed to foreign military activities in their maritime zones consider that, in principle, all military activities are not completely prohibited. However, in their views, these activities, the foreign military activities in coastal states' maritime zones, require coastal states' approval because these activities may be likely to challenge coastal states' public order or national security. In this sense, Article 298, Paragraph 1b of UN Convention on the Law of the Sea is elaborated to take into account the sensitivity around military activities. This provision provides for military activities exception from compulsory jurisdiction of international courts and tribunals established under Part 15 of UNCLOS. I fully agree with Professor Tanaka's argument that international judges are required to balance between the need for the effective settlement of international disputes and safeguard of consent of states when interpreting this exception. Professor Tanaka raised interesting issues in interpretation of this military activities exception by examining recent cases between Ukraine and Russia. Before disputes, as Professor McGarry pointed out, international courts and tribunals had some opportunities to interpret Article 298, paragraph 1b of UNCLOS or identify military activities under UNCLOS. I would like to make some comments on the basis of relevant case law. First, Article 298, paragraph 1b excludes disputes concerning military activities from compulsory jurisdiction. As indicated by arbitration between Ukraine and Russia, the word concerning may narrow down the scope of disputes applied by this provision compared to broader expressions such as arising from or involving. Furthermore, international courts and tribunals highlighted that military activities exception concerns dispute concerning military activities rather than military activities as such. Disputes subjected to this exception do not have to be completely and purely military activities. Therefore, mixed cases in which military activities are primarily engaged can be considered as subjected to Article 298, paragraph 1b. Of course, as Professor Tanaka pointed out clearly, the threshold for considering mixed disputes as subjected to this exception remains unclear until now. Second, Professor Tanaka explained the different approaches on identification of military activities between ICLS and arbitrary tribunal. I agree with Professor Tanaka's explanation. It is known that international courts and tribunals considered each party to disputes characterization of activities as a relevant factor rather than a determining factor for the identification. However, in the South China Sea arbitration, the arbitrary tribunal identified China's artificial building in Mischief Reef as non-military activities on the basis of China's characterization of the nature of the activities expressed through the President Xi Jinping's statement. In this case, China's characterization was a primary and determining factor for the identification. Meanwhile, although this does not concern interpretation of military activities exception, the arbitrary tribunal in Guyana and Suriname also took into account the parties' perception or characterization. The tribunal considered how the targeted vessel's crew perceived a threat of use by Surinamese patrol boats to identify the nature of the action in question. This perception was one of the relevant factors in the identification. In this regard, one may wonder whether international courts and tribunals do not show consistency in assessing and weighing factors to identify whether activities in question are considered military or not. However, in my opinion, China's artificial building in the South China Sea arbitration does not concern physical confrontation between China and the Philippines. This building activity was purely unilateral. Therefore, the actor states that is China's characterization of the activity was given high weight. And as Professor McGarry pointed out, the arbitrary tribunal in the South China Sea arbitration case considers circumstances of the confrontation between the Philippines troops and China's Coast Guard and Navy in and around the Second Thomas Shoal. The objective assessment, evaluation of the nature of the activity in question prevailed over the two-stage characterization of the activity in this case. Third, UNCLOS does not provide a definition of military activities, and nor does it a definition of law enforcement. I fully agree with ICLS and the arbitral tribunal's finding that we must not distinguish military activities from law enforcement activities solely on the basis of the type of vessels engaged in the activities. For example, in 2016, South Korea's Marines, naval agents, and Coastal Guard officers exercised law enforcement of operations in the Han River estuary near borderline between two Koreas to combat Chinese illegal fishing activities in Korea's waters. This operation was conducted in cooperation with and under the agreement of the United Nations Command because the Han River estuary is a demilitarized area subject to Korean Armistice Agreement of 1953. Although the naval force of Korea took part in this operation, it was a part of civil police in line with the regulations concerned. As this example indicates, the nature of actors or the types of vessels in question must not be a determining and sole factor in identifying military activities under UNCLOS. Moving on to Dr. NERI's presentation. I really enjoyed Dr. NERI's presentation, and thank you. Dr. NERI categorized maritime-related resolution of UN Security Council into two generations. I found this division very interesting, and I fully agree with you. The Security Council's interest in maritime issues has grown with a tendency to rely more frequently on Chapter 7 of the UN Charter. Let me focus on one resolution against North Korea that Dr. NERI briefly addressed in her presentation. The Security Council adopted Resolution 1874 in 2009 against North Korea. In this resolution, Security Council reaffirmed that the proliferation of WMD constitutes a threat to international peace and security. And under Chapter 7 of the UN Charter, the Security Council calls upon member states to inspect vessels with consent of a flag state on the high seas if they have information that provides reasonable grounds to believe that cargo of such vessels contains items relating WMD. If the flag state does not consent to inspection on the high seas, the flag state shall direct the vessel to proceed to a convenient port for the required inspection. Through this resolution, we can understand that vessel inspection on the high seas can serve to respond to a threat to international peace and security. One may raise a question of whether this vessel inspection on high seas under the UN Security Council resolution is compatible with the law of the sea. Under the law of the sea, there are exceptions from exclusive flag state jurisdiction on the high seas. Article 110 of UNCLOS allows a right of visit if acts of interference derive from powers conferred by a treaty. Although Security Council resolutions are not treaties as such, member states are obliged to respect and follow the resolutions adopted under Chapter 7 UN Charter in accordance with Article 25 of UN Charter. Therefore, we can say that Security Council resolution 1874 against North Korea is in line with Article 110 of UNCLOS. So we can consider that there is no conflict of norms between this Security Council resolution and the law of the sea. Finally, I would like to say again that two presentations in our session were very interesting and insightful. And thank you for listening to my discussion.
Thank you very much for that discussion. I really appreciate your comments, particularly your focus on the regional issues, which I found particularly interesting. Before I thank the speakers, perhaps I can just make two personal observations which were stimulated by the title which the organizers have chosen, Law of the Sea for the Next Generation, Effectiveness of UNCLOS Revisited. In my view, one of the great challenges to the law of the sea has already been referred to, and it seems to me that the peaceful use of the sea will be intimately related with our success in combating the great environmental and ecological threats humankind is facing. Yesterday, the UN declared we've come to the 8 billion inhabitant of this planet, and this human population has taken over from nature as the catalyst of environmental change, challenging over a very short period of time the ocean's ecological balance, which, in my view, has become so serious that it is certainly to be considered a threat. When I recall that in December 1988, we drafted the first climate change resolution of the General Assembly, where the global climate change was characterized as the common concern of humankind. Once we drafted that resolution, of course, just 6 years after the adoption of UNCLOS, our main concern there, and if you read the resolution, the only maritime concern referred to was sea level rise. Well, we now know that there can be no global ocean peaceful uses without protecting the global climate. The President this morning referred to the ramifications of this, and I think this is one of the challenges of the next Law of the Sea generation. The other point I wish to make, and in this respect I salute the efforts of Korea, is that at the end of the day, you may have the best law, but unless you have the human expertise to implement the law, then we will fail. The experience of IMO, where over 50 international treaties and literally hundreds of regulations have been successfully adopted to secure safer shipping and cleaner oceans, well, the experience has shown that unless you have human expertise to translate those international obligations into domestic law, then those treaties remain largely without enforcement. And therefore, again, I think we have to give particular importance to the training of officials, particularly in developing countries. And in this respect, as I said, I note over the years the great contribution which this country has made to help other states to become self-sufficient in advising on ocean issues. So on that note, on that personal note, I wish to thank the speakers for a very stimulating panel discussion. I really found illuminating both Professor Tanaka and Professor NERI's contribution, and my two colleagues here with their very illuminating insights into the discussion. Once again, I thank the government of Korea, I thank the president of the Korean Society, and I now declare the session closed. Thank you.
Thank you very much, Judge ATTARD, for making a great session and for your great comment. And let us give all the panelists a big round of applause and our Judge ATTARD for the great session. Thank you. And this is the end of the program for today. Thank you for your participation. And we'll come back at 10 a.m. Korea time tomorrow for the session number 2. Thank you.